points are remaining in this lesson, that is fundamental rights, fundamental duties and directive principles of state policy. Let's discuss fundamental rights. Fundamental rights is most important thing for every citizen of the country. In India, fundamental rights provides the social and political atmosphere necessary for the development of the personality of citizen. They are required for a person to lead a civilized life in society. They are also essential for the success of democracy. Actually, there were 7 fundamental rights mentioned in third part of our constitution. However, after the 44th amendment, the right to property has abolished. Now we are having only 6 fundamental rights. First one, right to equality. Equality, it means equal. We all are equal in front of constitution. There is no discrimination. Under this, all citizens are equal socially and economically before the law. No person can be considered on the basis of his social status or economical status. Everybody is equal in front of law. I am equal in front of law compared to Prime Minister, President and anybody. It means everyone are equal in front of law and nobody is above the law. All should get equal protection of law and none should be discriminated against on the basis of their caste, religion, gender or birthplace. Everybody is equal in front of law. Whether they belongs to any caste, any religion, any gender or any birthplace. No citizen should be subjected to any restrictions with regard to access to shop, public restaurants, hotels, place of public entertainment or place of worship. It means no citizens are restricted by these places. Anybody can enter to these places, whether it is shops, public restaurant, hotels, places of public entertainment or places of worship. And the last one, under this right, untouchability is an offense. We cannot consider anybody as untouchable on the basis of his religion, on the basis of his birthplace or on the basis of his skin color. This right has enabled every citizen to get an equal opportunity. If we will consider anybody as untouchable, that will be considered as an offense. This is the first right. Second right, right to freedom, which is mentioned in article number 19 to 22. Under this right, one who express his own opinion, it means we can express our own opinion, whether it is positive or negative, nobody can restrict us. And to conduct meeting without arms. Arms means weapons. We can conduct meeting without arms. To establish organization, we can establish our organization. To live anywhere in India, we can live anywhere in India because we are having right to freedom. To follow any profession and to move around the country. It is a protective right also, and no one can be arrested without proper reason. Nobody can arrest us or anybody without proper reason. No state law can snatch the life and freedom of a citizen. Even state law is not having that power to snatch our right of freedom. That is second right, right of freedom. First one, right to equality in front of constitution. We all are one. We all are equal. There is no discrimination on the basis of caste, gender, creed, birthplace. We all are one. Second one, right to freedom. We are having a right to freedom. Third one, right against exploitation. Exploitation means if somebody get exploited or harmed or troubled by someone, whether it is mentally or physically, we are having right against the exploitation. The aim of this right is to prevent exploitation of women, children, poor and weak. Begging, devdasi system, practice of sati, immoral system, immoral activities and forced labor have been prohibited. Employment of children under 14 of age in mining, industries, garages, hotels or anywhere is an offense. For that, they are going to get punishment by law. And to prevent these all kind of antisocial activities, Government of India introduced so many acts. That is nothing but Minimum Wages Act 1948, Dowry Prohibition Act 1961, Prevention of Bonded Labour Act 1976, Sati Prevention Act 1987, Human Rights Conservation Act 1993, Protection of Women from Domestic Violence, that is 2005. These are the rights which are protecting us from the exploitation. Next one, right to freedom of religion. Since India is a secular country, in our country no religion has given the status of national religion. All religions are equal in front of law. Citizens can accept any religion by their willing and they can follow its practices and propagate it. No one can be forced to pay taxes for the management of religious institution. Religious institution means you know that there is nothing but our temples, church and mosque. They are not paying any tax because no one can force to pay taxes for the management of religious institution. That is comes under right to freedom of religion. Use of religious places for political and other activities has been prohibited in our country. We cannot use our church, we cannot use our temple or mosque for any kind of political activities. That comes under right of freedom of religion. Next right is cultural and educational right. All citizens of the country have their own language, script and culture, isn't it? It is the duty of state to protect them. This right protects the interest of religious and linguistic minorities. It means minority means those who are less in number. Religious and linguistic. Linguistic means language. Minorities like Muslims, Christians, Jains, Buddha, Sikh, etc. No one can be denied admissions in government aided institutions or institutions run by the minorities. Right to education, RTE. So, according to this act, the Indian Constitution guarantees cultural and educational rights under Article 29 and 30. According to Article 21A, education is considered as a fundamental right. Based on this, government should provide free and compulsory education for children between 6 to 14 years. Next one is right to constitutional remedy. Remedy means solution. Constitutionally solution for our problem. The Constitution has not only given the fundamental rights to the citizen of India but also guaranteed them under Article 32. Article 32, in this article, it is been mentioned about all our 6 fundamental rights. Whenever the rights are violated either by a person or state government or the central government, the citizens may appeal directly to the Supreme Court for their protection. If somebody is violating our rights, somebody is not allowing to enjoy our rights, then directly we can appeal to Supreme Court, whether it is by a person, state or central government. If anybody is restricting to enjoy our fundamental rights, then we can appeal to Supreme Court directly. About this right to constitutional remedy, Dr. Ambedkar has called this as the heart and soul of the Constitution. If any individual or the government at the center and the state appear to violate a person's right, he has the right to approach the Supreme Court. The Supreme Court is empowered and enforce the fundamental rights. Hence it is called the protector of fundamental rights. Supreme Court is called as protector of fundamental rights. If our fundamental right get violated by any person or by the state government or by the central government, we can appeal to the Supreme Court. Then Supreme Court empowered to enforce the fundamental right. So that's why it is called as protector of fundamental right. Even the High Court has the power to pass the following rights under Article 226. Right to constitutional remedy. Under this, so many other things, other rights are there. The first one is habeas corpus. The order passed by the Supreme Court or the High Court to produce a person within specified time frame is called as habeas corpus. This protects the individual right of a person. If the person gets arrested by the police within 24 hours, that person should submit it to court. When police arrest somebody, then they will file FIR, first investigation report. Then within 24 hours, they have to present that person in front of court. That is called as habeas corpus. Even though before presenting the fellow in front of court, they cannot take any action against that person. Next one is mandamus. When the legislature, executive or any other subordinate institutions fail to perform certain duties or works, the Supreme Court or the High Court order them to perform these works. This order is called as mandamus. If any government office or any other government institution or any other subordinate institution, if they are not performing their duty, then we can complain against them. By that, Supreme Court is going to give order, Supreme Court or High Court is going to give order to them to perform their work. This order is called as mandamus. But the order cannot be passed against a private individual, governor or the president. It is not applicable to any private. Next is prohibition. When a subordinate court passes a judgment beyond its jurisdiction or the judgment is against the sense of natural justice, the higher court passes order against such judgments. And the order is called as prohibition. If any subordinate court passes any kind of judgment which is against the sense of natural justice, it means unfair justice, then the higher court can order against the judgment. The order is called as prohibition. This can be passed against the lower court by the higher court. Here, higher court can pass this kind of order to lower court, not lower court to higher court. Next one is certiorari. When the subordinate court passes judgment beyond their jurisdiction or against the sense of natural justice, the higher court orders the submission of records related to the judgment to it. This order is called as certiorari. When any subordinate court passes injustice or the judgment against a natural justice, then the superior court or higher court can order to that subordinate court as to submit the records related to the judgment. So this is called as certiorari. So these are our fundamental rights. Next, under this fundamental right, one more thing is there, that is co-warrant. The order directing that right person to occupy the right public office is called as co-warrant. The order is passed against the person who holds the public office illegally by the higher court. If any person is appointed to any government service and if the person is not belongs to that place actually on the base of his education qualification, or that person if illegally he occupies that place, then we can complain against that. Through that, that person can be removed from that position. That process is called as co-warrant. The order directing the right of person to occupy the right public office is called as co-warrant. The order is passed against the person who hold public offices illegally. Next is public interest litigation. It means if public interested about the public property and if they come to know somebody is harming that property, then they can take action. They can file case in court directly. Public interest litigations can be filed in court in order to protect the social rights denied to citizens and to protect public interest. Public interest litigations can be filed for a purpose of protecting legal rights, rights that are essential to protect life and to protect environment from being polluted. For example, if you come to know that if somebody is polluting Tandramaki Lake or any one factory is releasing poisonous water to that lake, then you can complain against the factory to court directly. So these public interest litigations can be filed by individual. Individual means if you are going by individual, that is called individual, or any social institution, or if you are going through any society or any one social institution or any one group, then that is called as social institution. But nowadays, court itself filing this public interest litigations.